I have raised the issue of how California statutes sometimes are declared invalid by state or federal courts, and some of the bases, whether they're federal or California Constitution based things, conflicts, whether preempted by federal law, etc. I've taken a short look at California statutes, looking back to some of the cases since the early to mid 1980s, and put together a listing of a number of California statutes that have been invalidated by federal and state courts since that time. Now, this list is not exhaustive by any means, but I think it goes to show the large number of court decisions invalidating California statutes. So, what are some of them? Uh, a state statute that would have banned mandatory arbitration agreements in employment relationships from AB 51 was invalidated by the U.S. Court of Appeals for the Ninth Circuit. A state statute that would have discouraged conveyances of federal land found in SB 50 that year. A federal district court ruled it violates the U.S. Constitution. A state statute that would have reduced damages that the United States may recover for wildfires caused by negligence of other parties. That was in Health and Safety Code section 13009.2, was declared unconstitutional by a federal district court. A state statute would have required charities and nonprofits operating in California to provide the Attorney General's office with the names and addresses of the largest donors. The U.S. Supreme Court struck down this statute in the case of Americans for Prosperity Foundation versus Bonta. A state statute that would have prohibited the sale or rental of violent video games to minors, found in Civil Code section 1746 and 1746.5. The U.S. Supreme Court invalidated that statute in Brown versus Entertainment Merchants Association. They found it violated the First Amendment. A state statute that would have required corporate board diversity for underrepresented communities in AB 979, LA County Superior Court judge invalidated that statute in Kress versus Padilla 2. And along the same lines, a state statute that would have required a specified number of female members on corporate boards in SB 826. The LA County Superior Court also invalidated that statute. That was in Crest versus Padilla 1. There's a state statute that would have allowed a private right of action against firearms manufacturers, found in SB 1327, and a federal district court invalidated this statute. There's also been a state statute that would have limited what physicians can say about COVID-19 in AB 2098. And here a federal district court invalidated that statute. There are also quite a number of appellate court decisions where state statute enacted by the legislature was deemed to have violated a voter-approved ballot measure involving, for example, campaign financing, Prop 73, changes to insurance rate regulation, Prop 103, Prop 36, and a number of other, again, voter approved ballot measures that the legislature tried to amend, and the California Supreme Court ended up striking those down. Also, in recent years, we've had a state statute that would have banned the importation and sale of crocodile and alligator products in the state. U.S. District Judge ruled that the statute was federally preempted. Also, a state statute that would have banned the sale of semi-automatic weapons to adults under 21. U.S. Court of Appeals ruled the statute was unconstitutional. And those are just some from the last few years. Again, there are quite a few dating back into the early 2000s and the 90s and the late 80s. But at least this gives you some indication that both federal and California courts have invalidated quite a number of state statutes that were enacted by the California legislature over the last few decades.